Okay, so let me introduce Lynsey now. Thank you for joining us. Dr. Lynsey Black is a lecturer in criminology in the Department of Law, Maynooth University. She researches in the areas of gender and punishment, the death penalty, historical criminology, and postcolonial criminology. Her first monograph on women, murder, and punishment in post-independence Ireland is forthcoming with Manchester University Press. She is currently working on the Irish Research Council funded projects Living Borders, Cattle Smuggling on the Ireland-Northern Ireland border, which explores border criminality through the 20th century. So without further ado, take it away, Lynsey.
Thank you very much. Okay, I presume if I make the screen big in this format, you can still see everything, yeah?
Yes.
Okay, good. Thanks. Very bad at technology. Thank you so much for asking me to speak today. As you said in the intro, I'm currently getting ready to send the draft of the manuscript to the publisher, and believe me, it was not meant to be still in draft form at this stage. But it's really nice to be able to come and talk about some of the ideas in the book. My research areas are gender and punishment, historical criminology, and increasingly an interest in how post-colonialism informs crime and punishment. So the present research very much brings this all together. The book emerged from my doctoral work, which looked at the small number of women who were convicted of murder and sentenced to death in Ireland after independence. And the book takes a wider view, which looks at all women prosecuted for murder from 1922 until 64, and 64 because there was a law reform in that year, which meant that death was no longer the mandatory punishment for women who had been convicted of murder, or indeed anyone who had been convicted of murder. So I was curious to see if being sentenced to death was the final stage of the capital process, almost the final stage, then how did it look from a higher vantage point? And what about the women who faced the same charges, the same ultimate punishment? What were their cases? What was their treatment and punishment like? So throughout these cases, the role of religious institutions as sites of punishment emerges just time and again. And that's really what I'm speaking about today. So I'll run through the origins of some of the sites that recur in the research. And then I'll speak about the women themselves, the women who find themselves before the courts and sentenced to a period of time in a religious organization or institution. And I'll talk about how the institutions formed quite a crucial part of Irish criminal justice in these years in terms of sentencing and punishment. And from the archives, we can start to see the meanings of religious institutions, certainly in comparison to imprisonment, for example. We can see things like the porous versus the sticky institution. It managed to be both. And the material offers a glimpse into how they functioned in what can be a really difficult area to get to because of the lack of transparency, the lack of material from the religious organizations. So then I'll move on to look at some wider explanatory frameworks like paternalism or religion in Ireland or postcolonialism. So in terms of the origins, I want to kind of turn first and look at, I suppose, where these cases came from. So the institutions that I'm talking about today mostly come under a few discrete types. So there was Magdalen Laundries, mother and baby homes, and then other religious institutions like Legion of Mary hostels or a home on Henrietta Street in Dublin. So Ireland's first Magdalen Laundry opened in the 18th century, and these were Protestant lay refuges when they were originally opened. And Maria Luddy has argued that they weren't carceral in their original conception, nor indeed through the 19th century, but carcerality must have formed a part of their function, because she has cases from the mid-1800s of women being sent there rather than the prison from the courts. And there are kind of three broad stages in terms of the development of the Magdalen Laundry. So they start very much as a policy transfer from London. The Dublin home is only the second home after London. And then the fact that they kind of were a lay Protestant institution initially is often, I think, overlooked because they became Catholic institutions later. And that happened kind of through the second stage, once you get to the early or mid 1800s, where you have increasing institutional power of the Catholic Church. So it takes over many of the existing asylums and it opens new ones. And then by the time you get to the kind of the post-independence period, you see them refashioned as a part of a deliberate institutional framework imagined for the confinement of deviant women and girls. Deviant always kind of meaning related to sex in this context. So unlike the Magdalen Laundries, the mother and baby homes were a largely post-independence policy. There was one in 1919 in Dublin, but generally they come after independence through the 20s and 30s. But there's also evidence of them as punitive, and June Golding has a really good memoir of her time in Bessborough, where she was a midwife, and she talks about the very punitive nature of those institutions. And we can read mother and baby homes, therefore, through this kind of post-colonial lens. And I think it's interesting that while Irish governments of the now have tended to emphasize Magdalen Laundries' pre-independence roots, obviously in an attempt to absolve themselves from some responsibility, the same cannot be said of the mother and baby homes. They were a deliberate post-independence policy. They were one component of that system which catered to women who had children outside of marriage. That was very much the purpose of that institutional network. And there are other discrete institutions within the research, such as the Henrietta Street Home. And these places, many of them had existed kind of prior to independence, but again, their use intensified after independence, as it became more likely that they would be used by judges as a disposal in sentencing. That was one of the big kind of shifts. So, as we are all keenly aware, no doubt, these historical institutions are far from past in Ireland. History is very much in the present. So, from the 1990s in particular, there was increasing concern about what appeared for the first time as a gendered system of exploitation and abuse. Concerns were sparked by a number of things, starting in the early 90s. The records of the burial of women who died in one Magdalen Laundry in Dublin caused real concern, and that led to the establishment of activist groups and survivor groups. And then later in that decade, in 1998, you get the Sex in a Cold Climate documentary, which was one of the first to present the testimony of women who'd been in the laundries. But as late as 2011, clearly, you have the Irish government before the United Nations saying that these experiences of confinement happened so long ago and in private institutions, and that most of the women went there voluntarily. So actually, it's nothing to do with them and they have no responsibility over it. And clearly the UN did not agree with that. And that same year, what becomes the McAleese Committee was established. And there have been ongoing issues with redress around that report, as well as the report itself. And questions about how to deal with the material heritage, the physical reminders, what's left of these places. And much more recently, the final report of the Mother and Baby Home Commission was completed last year and released to the public in January of this year. And it was established 6 years ago at this stage, in 2015. And it was tasked with, among other things, the burial practices of women and children who died in the mother and baby homes, and in a sample of the county homes. The county home was the renaming of what had been the Poor Law Workhouse. And the creation of that commission was largely the work of an historian, Catherine Corliss, who turned up the records of hundreds of infants who had died while at the Tuam Mother and Baby Home. And investigation of the site has presented significant quantities of children's remains not properly buried, not kind of officially recorded. And as with the Magdalen report, the work of that report, of that commission, has been met with criticism relating to things like all the familiar criticisms from Magdalen in terms of things like lack of transparency, the downgrading of the testimony from the women and people who were in the institutions. So in my own research, I'm very aware of these places, I suppose, as heavily contested sites in the present as well. And I've just put the text up there of Enda Kenny's apology on foot of the Magdalen report, which I hadn't realized until I copied and pasted the date, was 8 years ago today, if I'm doing maths correctly, which, you know, there's a good chance I'm not. So from 1922 to 1964, 292 women were prosecuted for murder, and they were appearing before the Central Criminal Court in large part. The vast majority of these women were being prosecuted for the murder of an infant, and there was at this stage in Ireland no distinction in terms of murder of an adult or of an infant. So it was a potentially capital offence. So while a handful of women were convicted of murder in this period, only 22, many, many more were ultimately convicted of lesser offences, usually manslaughter, but also concealment of birth and some other lesser offences. Most women entered a plea of guilty to these lesser offences, but some women opted for the risk, the unpredictability of a jury trial, and were convicted of lesser offences as well. And it is the women who were initially prosecuted for infant murder who were ultimately convicted of a lesser offence, for whom religious institutions form a key part of their sentencing. Certainly in the cohort that I'm looking at, there are other women going from the courts to the institutions, but within my cohort, it was cases related to infant murder. And there has been a lot of fantastic work on infant murder in the Irish context, and I've just put up some of the references there. And if anyone wants any of the references that I've spoken about today, just send me an email afterwards, and I'll pop them onto you. And the profile of these women is almost universally unmarried women, generally women in very vulnerable, precarious positions, from what is kind of known as the labouring classes, from rural or small town areas. And they have become pregnant outside of marriage in a society that is incredibly hostile to that. So what do we know about the role of religious homes in Irish criminal justice? Analysis of entry to some of the Laundries until 1900, for example, found that at least 1% of women entered from prison. That's working off quite patchy information. Also working off quite patchy information, though, the Magdalen report found that after 1922, just over 8% of entries were coming from criminal justice in some shape or form. So it seems clear, I suppose, that in the post-1922 period, the use of these institutions shifted. So what had been more accurately conceptualized as temporary places of refuge became, in the words of Crowley and Kitchen, long-term, punitive institutions driven by, in their terms, a quest for retribution and repentance. Common practices like hair cutting, the imposition of new names on women, work without pay, and regimes of silence really kind of indicate their punitive nature. And so after independence, they become something different than what they had been before. They are, as I kind of said earlier, they are kind of repurposed. And likewise, the mother and baby homes, which had been established to be one prong of the institutional response to unmarried motherhood, are pressed into service occasionally as well for women coming from the courts or for prison. And then you have Henrietta Street, and the use again there is intensifying. So Crowley and Kitchen have noted what they identify as a transformation in the scale and continuity of the exercise of power, the development of a much more systematic and connected regime. And clearly the power being exercised here is a religious power, but with the backing of the state. And there was a sense among those in power, religious and lay, that the years of armed struggle in pursuit of independence had created a plague of immorality, that there was a period or a surge of moral laxity, and that had to be eradicated. Across the decades from 1922, the most numerous of the sentences handed down was for a period of detention in a religious institution. So of 209 women convicted and ultimately sentenced, a substantial chunk of those women were sent to religious institutions. And all of these had been women who were originally prosecuted for infant murder. The requirement to spend time in the religious institution could be as a condition of probation or a suspended sentence of imprisonment or penal servitude. And generally the women gave their consent to go to these places on giving an undertaking as well to be of good behavior, keep the peace, and possibly to enter into a sum of money as an insurance. And as a sentence requirement, going to religious institutions kind of became more popular from the 1920s and 30s, and then be really dominant in the 40s. And actually in this decade as well, the number of women opting to put the state on proof and opt for a jury trial collapsed entirely. So by the 1940s, what you seem to have is a system, quite a well-oiled system, for guilty pleas and disposal to a religious institution. And of course, I'm not talking about huge numbers here, but the trend is ever greater reliance on institutions as sites of punishment. And I'm talking today about a certain cohort who come from the courts, but other women entered from the courts as well. While huge numbers of women were admitted despite having committed no crime at all. And I think that is perhaps what these homes are best known for, very much typified in films like the Magdalen sisters, this idea that it's unmarried women who, beyond that, have done nothing wrong, although that was enough, or who are perceived at risk. So the women within my research are smaller in number, but offer a different way of thinking about them and thinking about them in terms of one part of criminal justice in Ireland. So I got a lot of big quotes incoming. One of the things that makes it interesting is that religious institutions were under no obligation to accept the convicted women that were kind of presented to them. They could refuse women coming from the courts. They could refuse women coming on early release from the prisons. In the Cusson report from the 30s, which was looking at the industrial school system, they laid out kind of how the system works. And then they said, we need law, we need a statutory underpinning because it's not ideal the way it is. So they said, generally we accept judges are reluctant to commit young girls to prison, but they've no legal power to order their detention otherwise. And then they go on to say this is usually overcome because they send the offender to a home and the girl consents to go there and the home agrees to take her. But this is obviously undesirable because there's no specific power that enables this. And we are relying on the generosity of religious orders who take these cases without payment. And while the report states that the institutions received women without payment, that wasn't always the case. There was clearly exceptions to that, such as certain of the institutions did accept payment from the state. And there was also, I think from the record, this can be a bit of a grey area because there is a case of a woman, for example, who was sent to the Bethany home, which was a mother and baby home in the 40s. 2 years after she'd been sent there, you see the staff of the Bethany home looking for payment. They write to the Department of Justice to say, we have received no payment for this woman. We'll take money from anywhere, from you, the Department of Justice, or from the county council in which this girl used to reside. So there was, therefore, because it was entirely based on the goodwill of the religious organizations, there is negotiation that goes on behind the scenes to get women and girls into these places between probation officers, religious orders, and personnel in the courts. And I think this is just one letter on file from a 1938 case, which shows the ways this can happen. So months prior to her trial, the religious organization to which this woman eventually went said, as a rule, who don't like to take these girls before the case is tried, but we'll make an exception of her on the condition that we'll not be held responsible if she escapes. So it had to be very much negotiated, and there were probation officers as well, voluntary probation officers, often from religious organizations, who did a lot of this preparatory work. But the homes were under no obligation to take women, and they were also under no obligation to keep women that they admitted, even if they were admitted for, say, 15 months. If the woman proved refractory, the Laundries or the institutions could write and say, you need to take her away. And related to this idea of their voluntary and private nature is, of course, this lack of transparency, lack of oversight, lack of accountability. They kind of went hand in hand very much. So as the Cusson report excerpt noted, there was this general view that the judges are reluctant to commit young girls to prison. And this is very much the situation through the cases. Women were way more likely to be discharged, just giving an undertaking, than they were to be sent to prison. And this reluctance to imprison was coinciding with a marked downward trend in imprisonment. And that had been pre-independence, but continuing post-independence as well. And Ireland's imprisonment rate is dropping kind of considerably in these years. And I know Ireland's not alone, certainly, but it's happening in Ireland as well. And then what you were left with was that hardened cohort that the judges and the probation officers and the nuns didn't want these girls mixing with. So the contours of this debate really looked at the female prisoner population as a criminogenic influence on less worldly women entering prison. And imprisonment was just not a favoured place of punishment in the years that I'm looking at. Going back to the case of Bridget that we looked at before, where the nuns were like, we'll take her even though she hasn't been convicted yet. They explicitly outlined this fear of contamination if she were to remain in prison. And they say, you know, if there is to be any hope for her in the future, the sooner this can be done, i.e. her removal to the convent, the better, as there is another much older woman there also whose example and conversation would have a very bad effect on Bridget. And a probation officer writing in the 40s highlights the same issues again. She says these are hardened offenders in the prisons doing time, and their vile influence can be seen in the women after only a few days. So in contrast to the threat of contagion in prisons, the religious institutions were explicitly considered a more lenient punishment than prison, a place where a woman should be grateful to have been sent actually rather than prison. And you can see this in discussions with defense barristers and judges, where the defense barrister is trying to argue down a potential sentence, and they will always posit a religious home as preferable to the prison. And certainly at this remove, one of the things that is known about religious institutions is that they were hard to extricate oneself from. For the particular cases that I'm looking at, there is a sense in which that is both true and not true. They were at the same time highly sticky and also highly porous institutions, very much dependent on the case. And it really differed by type of institution as well. So Henrietta Street had a long history of taking women from the courts, and generally women sent there seem to have found it much easier to be released, to get out. And meanwhile, those institutions that were Magdalen Laundries, they had a different reputation. You know, it was known at the time that a lot of the laundries would just prefer to keep an inmate for as long as possible. And again, the probation officer, the same probation officer as the long quote before, she says, you know, it's less chance of contamination with the other inmates. The religious training, however, suggests and is all geared towards that women not returning again to society. And she said that's all very laudable, but not perhaps ideal for the cohort of women that we are dealing with, who clearly will not want to stay in Magdalen Laundries for the rest of their life. So the heads of the congregations had huge discretion, not just in the acceptance of women, but also frequently in when they were released. A woman pleading guilty to manslaughter in 27 was given a suspended sentence and told to go to Hyde Park in Dublin until the Reverend Mother consents to her discharge. So that's right there, the power and the authority for release being handed over to the religious organization. However, it's also the case that in the right circumstances, these institutions could be porous, that women could leave prior to their terms being completed. One case is Elizabeth McNamara, who pleaded guilty to manslaughter in 1946, and she was sentenced to 15 months in Gloucester Street Laundry. But then the Minister of Justice receives a letter from her father, who says that he would like her to be released because he has found a job for her. So the minister requests the probation officer to make inquiries on this matter and liaise with the religious organization. So on first communication, the order comes back and says, no, she needs to be here for a longer period of time. And they kind of schedule it for review again in 3 months. And in 3 months, the probation officer goes back. And at this stage, the order says, yeah, fine. And she's released 2 days later. So it was possible that when women possessed the right kind of social capital, early release from homes could be secured. When there was, for example, a willing and crucially respectable wider family who were prepared to petition on behalf of their confined relative. But nonetheless, the system represents a hugely stark lack of transparency. Smith has outlined, for example, that because Henrietta Street accepted funding for its work from the late 1800s, they had been subject to inspection, but the Laundries consistently rejected inspection, actively campaigning against their inclusion in legislation that would force them to be inspected, such as the factories legislation. So this idea of the sticky or porous nature of each of the women's experiences, there was no oversight over it. The fact of release was entirely very much within the gift of the religious organizations. And while many of the probation officers, and there weren't that many, were diligent in checking in on the women, there was a huge amount of deference to the views of the religious orders when it came to whether or not individual women should be released. So how do we explain their use? And kind of one thing to note is that these kinds of institutions are not uniquely Irish, obviously. Mother and baby homes, Magdalen Laundries, those kind of religious refuges for women had been around in many, many other jurisdictions. And O'Donnell and O'Sullivan last year said that not uniquely Irish, but perhaps the intensity of their use after independence is something that is perhaps uniquely Irish. And there is work, for example, on Scotland. So what happens in the post-independence period to ensure that they become kind of deeply embedded in criminal justice? So I've previously written about religious institutions as an expression of paternalism. In 2018, I wrote about post-reprieve experiences for women who'd been convicted of murder and sentenced to death and then reprieved. And the reprieve sentence was life imprisonment. So of 21 women who were reprieved, all but only one woman was executed in Ireland in this period. Of 21 that were reprieved, like over half of them were conditionally transferred from prison to a religious home. And that was the condition on which they were allowed to leave prison. So 11 of them end up spending a further period of confinement in a religious home after release from prison. And the mercy that is extended is because of patriarchal gender relations. Mercy is applied very much in a way that conceptualizes women as other, as less than, as childlike, And this was very much in keeping with the gender roles in this period in Ireland. And Ireland in the years after independence can be characterized as rigidly patriarchal. Evelyn Mahon talks about it as a private patriarchy and characterizes it in terms of women as caregivers, women as in the home, and male as the head of the family in a very kind of sacrosanct position. And this normative patriarchy is reinforced by legislative initiative that really takes off in the 1920s and continues for the decade afterwards, which is actively working to suppress women and the idea of women as a public person. And you can see that in things like the kind of the headline items are the banning of contraceptives, the banning of divorce, the exclusion of women from juries, and the marriage bar. And clearly, you can't really understand these developments without understanding religion in this context. Many of these legislative endeavours from the late 20s were very deliberately reflections of Catholic social teaching. The influential status of the Catholic Church on independence was a position that had kind of grown through the 19th century, ensuring that by the time we got to independence, Catholicism and Irishness were one and the same thing. By mid-century, the church had become, in the words of Inglis, its own independent power bloc. And the British state had handed over significant control through the mid-1800s. And that was manifest in areas like health and welfare and education. So on independence, it had a substantial backing in terms of infrastructure and institutional power. And it kind of wielded this power through the first decades of independence with very little to rival it. And the legislation that came in, or the policies that came in, all very much kind of reflected Catholic teaching on this in terms of the family and sexuality and morality, culminating in the Constitution in the 1930s, where you have the enshrining of the special position of the church, as well as the creation of an article on women's place in the home. And critically as well, the Catholic Church was pivotal in the development of Irish criminal justice and how it developed. For example, in the creation of coercive confinement, and Conway writes about the guards that they were really rubber stamped by the fact that they were explicitly Catholic, which made them explicitly Irish as a police force. You can see it in terms of imprisonment as well, in Branken's work on pastoral penalty, where she's talking about a conservatism which is very kind of Catholic. You can see it as well in the development, the very slow development of probation services, which was always kind of beleaguered by the fact that they had been farmed out to Catholic Church organizations. And that's Healy and Kennefick are talking about that. And they were so slow to develop because of the Catholic principles, which stated that the state should not be taking on these roles in welfare and health, that it should look for voluntary organizations who would fulfill these roles with state backing. So it would seem hardly surprising, I suppose, in this context, when it comes to the question of the bodies of women, that the church would get involved, would play a role in their control and confinement. And early in the life of the new state, you have laxity, moral laxity, and unmarried motherhood being identified as an explicit threat to the new state. Sex being the offense here, being the obvious manifestation, and the unmarried mother being the very obvious manifestation of this. So despite the kind of professed non-interference, and that was one of the principles, the privacy of the family, non-interference within the privacy of the family, that doesn't necessarily apply whenever it comes to single women who have become pregnant. And it's very class-based as well. While the idea of the privacy for the family and non-interference was very much premised on an idea of kind of middle-class respectability or respectable working-class families, that is not happening when it comes to unmarried mothers, kind of most of the time. They receive no such protections. Because these are offences which are viewed as more moral than criminal, there is an argument that the state has no jurisdiction to punish, hence the kind of movement into private, voluntary religious institutions. And these were clearly, so the Catholic Church already was kind of hugely influential in areas of kind of welfare and health. And these were very much not understood outside of the framework of morality. They were one and the same. The role of the Catholic Church in taking on health and welfare duties of the state was very much to do it in a Catholic way. So when it comes to justice, I suppose we should not perhaps be surprised that the church is willing to take on these particular cases and to create this institutional network of confinement for women. And I think as well, clearly I'm coming to the end now. One way of understanding this, one additional way, layers upon layers, is that these religious sites are used as sites of understanding and imagining and making real the new nation. So you have an existential threat to the new state, and that is lack of morals, moral laxity, personified in the person of the unmarried mother. And it is identified as a very explicit threat to the new Catholic state. And it is a behavior and a scourge that requires extreme measures in the form of the confinement of these women. So Mark Brown, writing in the context of India, has talked about how there is a colonial desire to defend against, chronic instability or the things that threaten the colonial state. But he also notes that this doesn't just evaporate on independence. At the point of independence, freedom can remain just as hard to come by for many groups. And Ireland's positioning as an independent nation was explicitly predicated on its Catholic status and very much defining itself against England, the colonial power. Additionally, and somewhat ironically, Catholic teachings on gender were hugely reinforced by Victorian ideas of gender, which kind of came together to underpin understandings of what women should be in this period. So this idea of women, unmarried women who engage in sex, as being identified as an explicit kind of threat to the stability of the nation is something that I think underpins the willingness to confine women in these sites for long periods of time. And the fact that they were used as sites of confinement for offending and non-offending women, I think reveals their true purpose is not to punish crime. That's not what orders or the church is concerned about. They're concerned about punishing lack of morality, the sin, rather than the crime. Something that the state should have a limited role in, but that should generally take a hands-off approach to and let the church go on and do its business. And this is not necessarily a unique thing in terms of post-colonialism. The idea that, many anti-colonial movements flirt with higher ideals than they ultimately end up governing with has been noted. And one of the groups who is frequently dispossessed on independence can be women. And I have no conclusion slide because I just finished the PowerPoint before I started this. So I'm just going to end with the last point on that. And it's kind of my contention in Ireland that the Catholic post-colonial state took up coercive means to control something it perceived as a threat. And that was unmarried women who engaged in sex and became very manifestly pregnant. Okay, I will now stop my share. Thanks, guys.
Thank you, Lynsey. Yes, people are clapping at this point. You would be getting a round of applause.
Cool. I need a glass of water.
Okay, I'll pass it on to MJ for questions.
Yes, thank you so much, Lynsey. That was excellent. We have a couple of questions in the chat, but if people want to raised their hand and ask a question out loud, please do. You can raise your hand in the reactions tab on the bottom of Zoom. So raise your hand if you've got questions. Otherwise, I'll start by reading out some of the questions in the chat. And the first one was from Kirsten Anderson. Very interested to know more about the policy that enabled mother and baby homes and how judges used them as a disposal. Were the homes independently run or by the state? Both? Were they regulated? Thank you.
Yeah, and so that is kind of the basis of the recent report from the Mother and Baby Home Commission, which is clearly very, very long. But they were both. Some of them were privately owned by the religious organizations. Some were owned by the state, kind of by the local authority, but the management was given over to religious organizations. And in terms of the mother and baby homes, they were certainly supposed to be inspected, and they were inspected. And one of the things that comes out of the most recent report is, I suppose this was already known, but to have it kind of reiterated, just the huge levels of infant mortality in the mother and baby homes. So in terms of the inspections, the inspectors were generally there to look at were they fit sites for children to be born? Were they fit sites for children to be placed in? So then, because the women who are going from the courts comprise like a tiny number, they kind of fall out of they're not really as much of a priority for those inspectors. They kind of remain the job of the probation officers. But yeah, the recent report goes through in kind of really sobering kind of detail, just the levels of infant mortality, despite the fact that these were constantly being inspected.
Thank you, Lynsey. I think Deborah has a question.
Hi, Lynsey. Thanks so much. That was just really so interesting. I just found it so fascinating. It was great. Thanks so much.
Thank you.
How were they legitimized? I mean, was there actually, so it seemed from your talk that actually it was just an option that judges could pursue, but there was no legal basis for it.
So if they went on probation conditions, there was legislative basis which said up to a period of 3 years of residence in an institution, although nothing named. So that was 1914 that was brought in. If they went as a condition of suspended, they're supposed to go to prison or penal servitude, that had no legislative basis, but had been kind of held to be constitutional by the Supreme Court. And there were other ways. If it was post-prison, it was late 1800s acts. So there was a kind of a mishmash of legislative and other provisions, which on the face of it created a legal stamp for the way, but they were never used within those kind of legislative confines. The way they were used always kind of overspilled the provisions for how they were supposed to be used. But it helped that they had legislative backing in many cases with probation. So yeah, it's a weird piecemeal putting together with a hefty dash of discretion as well. And Ireland's so discretionary with sentencing, even still. And back then it was, what does the judge want? Well, that's what the judge gets.
Thank you, Deborah.
Thank you.
And thank you, Lynsey. Next question was in the chat from Chloe. I don't know if you want to unmute and ask it. Yeah, go ahead.
Hi, Lynsey, and thank you so much. Basically, just a question I have. I'm a barrister, but massively interested in this area. And something that I just wanted to know was from a kind of more practical point of view. You'd said that these women, they weren't challenging the charges that were being put to them. And I was wondering, was that coming from a kind of access to justice point of view? Were they just not getting legally aided? Did legal aid as such exist in the way that we understand it now?
Thank you. I've been trying to work out myself to what extent women were making choices to either plead or put it to the test or not. And it's really hard to get a sense of the role because they were all assigned barristers, because they were all exposed before the Central Criminal Courts on the murder charge. And it's hard to get a sense of to what extent the barristers consulted with them or what they understood of the process. So you have some cases in the 20s and 30s of women being asked to plead and pleading guilty to murder, which clearly causes mass panic in the courts, which kind of suggests that they haven't been told what to do by a barrister. And you can see in the 20s and into the 30s, if a woman opts for a jury trial, she is more likely to be discharged. She's more likely to get an acquittal. So then I don't know, by the time you get to the 40s, that's not happening anymore. And I don't really know why. No one is risking it as much anyway. So you just have, you know, a machine for guilty pleas. But if they had have challenged it, it seems from the earlier decades that they would have more likely just been discharged from court. But yeah, I would love to know what was going on.
I wonder if this is just me completely speculating, but I wonder if did we have a changeover of judges or something like that, that maybe at one stage there was particular judges that were going to be more lenient, and then that changed and they were saying either the barristers weren't advising or were advising, saying, actually, do you know what, this person isn't going to give you what you want. So
yeah, it could be, because like in terms of those 20s judges, that is a particular cohort that is very much the Victorian judge. It takes them a while to kind of retire off. So yeah, potentially the barristers are trying to size up the judge that they have. But it seems like that's not enough. And it's just, as in like the barristers are just saying, just plead to this. It's better for you, just plead to, and manslaughter becomes by far the most common plea in the 40s as well, rather than concealment. And I think it just becomes like habitual. That is what is happening so that's what continues to happen. And it just becomes what happens through the 40s. If you have any other ideas, feel free to email me and I will.
Super, thank you for that. That was really, really interesting. I just kind of, that was something that was just going around in my back of my head. So thank you.
No, thank you.
Right. Remember, guys, you can all raise your hands if you want to say a question out loud. But in the chat, the next question was from Christine Bell. Was there differential treatment in terms of referring to a religious home between Catholic and Protestant women?
That's a good question. So the vast majority of these women were Catholic. I think you get to a stage in like 51 where 95% of the population is Catholic. But there was the Bethany home, which was a Protestant mother and baby home. And then you have one Protestant woman who's convicted for the manslaughter of an adult, and this doesn't go in her sentence, but it becomes clear that after she's been sentenced, there is that kind of negotiation behind the scenes that she will go to a home in Belfast because she's Protestant, and that's the suitable home that she should go to. So the institutions were very, very demarcated by religion at a time when that was one of the overriding features of the church, that all the services would be by religion. I don't know if I've answered your question.
Yes, I mean, I was kind of guessing that, but I was just curious. I suppose what I'd been wondering was if there weren't sufficient provision, did that mean there was a differential rate on who ended up stuck in jail, was the first thing. And secondly, I was actually wondering, this maybe sneaking in an additional one, was there something common that determined whether people got the probation offer of the homes, if you like, versus, I don't think you mentioned that, but I was just wondering, was there any pattern to how that decision was made?
Thank you. And on the first question, because there was so few, Protestant women that were kind of coming before the courts on this, the number of their institutions, like the Bethany home or the Belfast home, they could always kind of handle it. But it seems very small numbers to be working with, but it seems like, for example, the Bethany home was just easier for women to get out of. So again, like a different approach to the Magdalens. And then the second question, in terms of who was offered this, it was more likely to be not married, because married women were coming before the courts as well, charged with infant murder. And by and large, they were way more likely to be found guilty but insane, or to be discharged So it was unmarried women, and that was who it was viewed as appropriate for, largely, unless there were some women who were married, but their children were living with the grandmother and their husband had left them, in which case they have no protection anymore. So then they can be put into the institutions.
Thank you, Lynsey. And thank you, Christine, for your question. Moving on to Rui. If you want to ask your question out loud, you can unmute, Rui, or I can just read it out. Well, I'll start by reading it out. Are there any indications?
You can read.
Oh, okay.
Yeah.
Thank you. Thank you, Rui. Are there any indication mensurable to conclude about ethnic groups with religious inequality, or that religious are a cause of gender poverty or economic prosperity?
So in terms of the kind of the class aspect, I can take that, because that was, I suppose, the profile of the vast majority. They were precarious, kind of working class women with little else, no options. Especially there are some comments from the church at one stage, probably in the 1940s, where the church is saying, like, obviously, you know, the poor women who come to us who have killed their infants are actually not as bad as those more affluent women who use contraceptives. But clearly they had no power to get at that cohort. And I think I've missed the first aspect of the question. Sorry, Rui. I think it was reading.
It was, are there any indications mensurable to conclude about ethnic groups with religious inequality?
So I think it's interesting in terms of there's not a huge amount of work on this, but the idea of the traveller community and how they experience criminal justice and religious control. And there is work on it, just, I suppose, not as much as you would like, but that is changing. And I think that as a group in Ireland, they would have been a cohort that experienced discrimination based on that. And occasionally, through the cases, you can see women who are described as women of the travelling community who are viewed as almost possessing a weakness handed down from parent to child, and they receive a disposal accordingly, kind of based on that, because of a presumption that they are weak-minded. That presumption of weak-mindedness, though, was basically applicable to anyone who had sex outside of marriage. So it was a fairly wide-ranging application.
Thank you, Rui, for your question. And next is Connor.
I think Rebecca just raised her hand.
Oh, we can take Connor first and then Rebecca.
Okay, go ahead.
Okay, hi, I'll try and be quick. Hi, Lynsey, thanks for a really nice talk. We've had an exchange on a related issue not that long ago, but I was thinking the patterns that you're seeing in Ireland and the reference you made to some other context there, what I'm wondering is whether there's a criminology around church-state crime that might be emerging, and if there's other things happening elsewhere in the world, whether Catholic Church related or otherwise, that you feel you can connect with. Because it really feels to me almost like state corporate crime, but now we have church state crime. So if you had any thoughts on that, that would be great. Thanks, and good to see you.
You too, Connor. I absolutely agree. I think in terms of looking at Ireland, kind of first and foremost, you can't understand criminal justice, crime and punishment through the 20th century without considering the role of the Catholic Church, both in terms of the functions it provided for the state, as well as the harms and abuses that it perpetrated. And I think, certainly when I see international news reporting of things like the release of the Mother and Baby Home Commission, and it's always this idea of, dear God, Ireland again. And I think that is part of our narrative now, but I think that also, there needs to be a wider project which looks at this beyond Ireland, trying to connect it up. And I entirely agree. And at some point in the future, I would very much kind of like to do, and you know, like the idea of kind of cross-national comparisons and how that works would be fascinating. And I have been thinking about it, and then thinking about what are the restrictions to that. And I suppose a lot of the countries most immediately that I'd be like looking to compare would be, you know, countries like Portugal. And so there are kind of ensign countries that suggest themselves, I think, for kind of comparative analysis. But this idea of how religion was embedded in many cases within criminal justice, but also perpetrating harms at the same time, I think is incredibly worthy of study. Oh, I basically just said, yes, you're right. Sorry, Connor.
Thank you, Connor. Rebecca, would you like to?
Yeah, sure. Thanks so much. That was so interesting. I suppose it was in response to something Rui was asking, and sort of the idea of race and ethnicity. And then it kind of links nicely to the question I have, and that I managed to mistype in the group chat. Anyway, so in the most recent report that's been released by a commission, they really downplay the existence of racism and abuse in that respect. But the reality was a lot of women and children who were incarcerated in all these institutions, they would have been mixed race. I mean, it was a tiny proportion of the Irish population at the time, and like it's still a very white country, but there was definitely a racism thread running through it. Yeah, actually, Lynsey, if you've more information on that, would be really interesting. But my question, which kind of links, you mentioned sort of the post-colonial frame in relation to Ireland, and it's something I find really interesting because there's that, again, that tension between we are a post-colonial country, but because we're predominantly white, it kind of, there's that tension there. So basically, if you could tell us more about the post-colonial work you've engaged with and how it applies to Ireland, how it doesn't, I'd be really interested to hear more about that. Thank you.
Yeah, absolutely. The recent report is really interesting on that. And I completely agree that well, for a start, like you say, kind of said that didn't happen. Here is a bunch of survivor testimony that says it happened, but we find no evidence that happened. As you well know, this idea of like, what is evidence in that context? Oral history and survivor testimony not being considered to be evidence. And I think the post-colonial thing, the whole post-colonial thing is really interesting in Ireland. And myself and Louise Brangan, who I think is, no, great, she's gone. And Deirdre Healy from UCD are kind of working on an edited collection at the moment about this, like, understanding our Irish criminal justice through post-colonialism, because there is a tension. The idea of us as kind of complicit in empire because of, you know, a kind of white privilege, and yet being, as I think Young says, you know, England's first and always exceptional colony. So this tension between being oppressors and the oppressed, which I think is entirely fine, and there shouldn't be the rigid categorization of one or the other, because we know that's not how various phases of colonialism work. And I think that this is an area that is increasingly in Ireland, a lens that people are willing to adopt to understand Ireland in the 20th century. So yeah, thanks for the question.
Thank you, Rebecca, for your question, and Lynsey for answering. We've come to the end of the event. So thank you again, Lynsey. Andrea, do you want to take over?
Yeah, just thank you everyone for your questions and for coming, and especially thank you to Lynsey for everything. I was just going to say to keep an eye out for our next event, which is going to be on atrocity crime in Bosnia and Herzegovina, March 1st at noon, but we'll send around some information about that. Thank you everyone
for having me, and thank you
very
for
much.
all the questions. Thank you, guys.
Thank you, Lynsey. Bye, everyone.
Thank you. Bye.